Good evening. It's Steven Leskin. It's about 6 o'clock on a Thursday night, and you are at Oregon Divorce School. You're not getting an image of me due to technical difficulties, but the quality will be nonetheless absolutely, totally terrific. So I do these seminars, webinars every other week or so, and my goal is to give people like just good, objective information about divorce in Oregon. My name is Steven Leskin. I've been a divorce lawyer in town in Portland and in Oregon for about 30 years, going on 30 years now. And I do these as just a way of helping people learn about divorce. I've come to realize over the years that the more people know, the better informed they are. Obviously, the better able they are to make decisions, the less stress there is, and hopefully it helps them get to a better place in life with a little bit easier transition. Uh, I don't take questions during the seminars. Seminars are not set up to take questions. Uh, so if I say something that triggers an interest, please call me. My contact information is at the end, and I'm happy to take a call. Tell me that you're watching the seminar, and I'll be happy, more than happy to chat with you. If you like what you see, please, give me a thumbs up, as is the thing that we do now. What else can I tell you? The information I'm giving you tonight is, straight from the horse's mouth. This is not intended as an infomercial. I don't really talk about myself or try to sell my practice. I'm just trying to get people good, solid information on divorce law. So let us begin. Tonight's topic is divorce pleadings, and a pleading is a document that gets filed with the court, and so that's we're going to talk about all the different types of documents that can get filed and what they mean, and what you should know about them. I probably could talk for hours on like any of these documents, any of these individual documents. So this is just kind of a quick overview of what is going on in general with legal documents that are filed in the courts. So again, my name is Steven Leskin. I've been practicing law in Oregon since 1992, and in Portland for most of that time. I've been litigating. I've done all different areas of law in the last 5 years or so. I've been focused on divorce, even though I've been doing divorce for about 25 years. Uh, I also am a mediator. You can find me at leskinlaw.com, which is where my mediation practice is at. And so I do mediations, divorce mediations, and arbitrations. There's my contact information if you want to reach out to me at some point. Again, I was admitted to practice in 1992 and tried cases probably in most of the counties in the state. All right, so let's look at the couple of core documents. Any lawsuit, whether it's a divorce or a criminal case or a personal injury case, starts with an opening document. And that document is either going to be called a petition or a complaint. People get charged for criminal cases, get charged through a complaint. If you were going to sue somebody for rear-ending you, you would start with a complaint. Cases that request something from the court are called petitions. And so in family law, there are multiple different types of petitions, but what we're going to be talking about mostly is a petition for dissolution. And what the petition does is it tells the court, we're starting a lawsuit. This is the document that starts the lawsuit. And a petition will contain the, will define out who the petitioner is, the person who files, the respondent. In a divorce case, the statutes require specific information about age and identifiers and what you want. So the other thing that a petition does is it tells the person you are suing or divorcing that you want spousal support or you want custody of the kids or you want a division um, of the marital property. So all of those things go into a divorce, and they tell the other side, um, "This is what I'm seeking the court to give me." Right? And so if something is not in a petition, so for example, um, uh, somebody doesn't plead that they want spousal support. You can't go to trial, walk in court, and say, "Oh, I changed my mind. I think I want spousal support today." The other side has the right to know that that you are going to ask for spousal support, so they can prepare to defend themselves. Hold on for 1 second. Oops, wasn't quite done with that. Hold on, 1 second. All right, this is Steven Leskin. Happy to see everyone tonight. It is 6 o'clock on a Thursday, so let's just jump into it. So tonight's topic is divorce pleadings, and a pleading is a document that gets filed with the court to move a case forward. And so tonight's topic is all about divorce documents and how they help people move their case through the Oregon courts. Again, my name is Steven Leskin. I'm a divorce attorney in town. I've been doing this for well on 30 years. And my intent with these is just to give people information in order to help them reduce their stress, make better decisions, and generally have a better handle on what's going on in their situation. I don't take questions during the seminar, but I will be delighted if you call and say, I watched your seminar, it's not online, and I have some questions. I'll be happy to go through things with you. My contact information is at the end of the seminar. You can also find me by searching Steven Leskin online. I don't intend these as a seminar. I'm not trying to sell my practice or anything like that. I'm just trying to get people uh, uh, objective information that will help them through, what's obviously a difficult time in their lives. So let us begin. So tonight we are going to cover me. We'll start with a little introduction. Then I will introduce pleadings and the core concepts that we need to talk about tonight. We'll talk about the core documents and talk about motions, declaration, order, and then trial documents. And that should get us pretty much to the end of the hour. So as I said, my name is Steven Leskin. I have been an attorney in Portland for 30 years. I was admitted to practice in 1992. I've been doing divorce law, family law for about 25 years. Um, I also run a mediation practice. So if you're considering an alternative to litigating, uh, you might want to take a look at my website at leskinlaw.com and give me a call if you're so inclined. Be happy to hear from you. All right. So we're going to look at core documents. So um, this should have said core documents. It shouldn't say content title. That's a mistake, but just don't say anything and we'll keep it between, you and me. So uh, the two documents that every lawsuit has, whether it's a personal injury suit or divorce or criminal case, every every lawsuit will start with either a petition or a complaint. You make a complaint against a third party. So, for example, like if you're like it's a criminal case, the complaint is against a person, right? A petition is you're asking the court for something, right? You're asking the court to give you something. So you're petitioning the court for child support or for custody or for parenting time. Whereas in a complaint, you're complaining about somebody and you want the court to impose something on them, right? Or a personal injury case, like you're asking for something from that person. So it's a little bit different, but any lawsuit will start with either a complaint or a petition. Every lawsuit will end in judgment. The whole purpose of going through a lawsuit from a lawyer's perspective is to get the judgment that you want. And in divorce case, it's going to be general judgment of dissolution. And that judgment defines your post-marital relationship with your spouse. So if you've asked for spouse support in the petition um, and you get the order for um, spouse support will show up in the judgment. Petition lays out does a couple of things. It tells the court that a case is coming on. It tells the court that you need to set aside a case number and um, open a case. And serves the function of giving notice to the other side of what you want. So in the family law example, supposing you want custody of the kids, you would say, that mother wants custody of the kids. You'd use a little better language than that, but that's the gist. If you wanted spouse support, that would go into the petition. If you wanted an unequal, either an equal or an unequal division of the property, that would go into the petition. Uh, a petition is responded to with an answer or a response, and the response says, "I admit to these things" or "I deny these things," and it can also include a counterclaim. So, uh, wife files a petition, but husband wants spousal support. Husband would counterclaim for his spousal support. Judgments are interesting documents, actually. The first section of a judgment is called findings of fact, and then it gets into an order, and then it gets into a money award. So every judgment has at least those three sections to it. The findings of fact are important, and I don't think enough attorneys realize how important they are. Findings of fact lay out what a couple's um, position is at that time. So going back to the spouse, well, let's take child support. The judgment and the finding of facts will list out all of the factors that the court considers when putting together a child support award. So husband makes this much, wife makes this much. There's this many overnights with mom. There's this many overnights of the kids with dad. There's veterans benefits or Social Security benefits, or there's money for a union or who pays insurance. All of that is listed out in the findings of facts, and then those findings of fact become important because later on, if the judgment needs to be modified, right, there's a basis for the modification. So, uh, for example, uh, dad's paying child support, and he says, "Well, I want to pay child support, but I want to modify the amount of child support because I'm making less money." So the original judgment has a baseline of what the parties agreed or what the findings of fact were in a trial that husband was making, $5,000 a month or $10,000 a month or whatever it is. So that becomes the starting point for a modification or for an argument about modification. So the findings of facts are very important. It will lay out what the real property is, who the children are, uh, what the financial situation is, if there's kids or an award of child support is going to be made. So the findings of facts in a judgment are um, very, very important that they're drafted correctly and accurately. Uh, After the findings of fact is the order section, and the order section because it will say in bold, "It is hereby ordered and adjudged," and that's the section that actually is the court order. That section says, uh, "Father will pay mother child support in the amount of $200 a month or $1,000 a month. Uh, Mother will get exclusive use of the house, or mother will retain the house and pay husband $50,000 for his share of the equity, right? So those are some examples of orders in the order section. The order section will track uh, all of the all of the issues in the divorce, whether there's a home that's going to be sold, or retirement accounts, or what's going to happen to personal property and the cars and the debt. All of those things are subject to a court order, which is found in the order section of the judgment. The last section of the judgment is called a money award, and that's the money award is very important because it's what gives the judgment or the one of the parties the ability to engage in collection actions against somebody who doesn't pay. So the money award will say, father owes spousal support to mother in the amount of $600 a month. That money award, um, independent of what the order says, that money order becomes the basis for a garnishment or execution of the judgment against the father's assets, right? So the money award is just a summary of who owes what. Um, orders are never contingent. Like you can't say, well, if this happens, then this will happen. Orders aren't written that way. Orders are, this will happen. That's what makes it an order. And so the judgment reflects that um, that dad will pay mom, mom will pay dad, the husband will pay wife, spouse support, dad will get the house. So um, those are the kinds of things that are in the order, and it just goes through, all of the various issues in the case, and the judge decides it or the parties agree. Uh, a judgment can either be agreed by parties, in which case it's stipulated, or if you go to trial, then it's just a general judgment. There's also default judgments, which is another way that a lawsuit can end if the other party just doesn't show up. So those are like just a really quick overview of what documents start and finish a case. Okay, now we're going to talk about motions, declarations, and orders. And I'm going to explain what each of those are. Uh, so again, I should say motions, declarations, and orders, and not content title. So a motion is a request from the court to do something, right? A motion ends in an order. And uh, if you're the most common one would be the most common motion is clearly a motion to set over a trial date, to postpone a trial. Attorneys do that all the time. And so you file a motion, and the pleading will say, motion, petitioner requests the trial date be moved to, 3 months out. And so you'd send that to the other side, and they say, well, we don't agree with that, or we agree with that. And then you tell the court that they agree or they disagree, and then you cite what the authorities are, and then you file it with the court, and the other side could find a response to that saying, we disagree with this because of X, Y, and Z. How the court knows to decide, how the court knows to make a decision is based on what's in the declaration. And declaration is a sworn statement. So, for example, maybe the attorney has to move a trial date because he has a conflict with another court case, right? And so he'll say, I'll be in Multnomah County on the same day as this trial, and I'm therefore requesting the court to postpone the trial. And so the court is relying on that sworn statement. And then, of course, the order, motions and declarations are now in the same document. Orders are a separate document, but they all get filed at the same time. And if the court, if the movement, the person putting forward the motion says the other side agrees, then it's just pro forma. The court will approve it, usually, and it just happens, pretty quickly. If a party, the other side wants to contest it, they have 14 days to file a response, and then you get a chance to reply. So then it becomes a longer process, and the judge has to make a decision. And that's more likely on a more involved motion than just a motion for to postpone a trial date. For example, a more sophisticated motion in a domestic relationship case, maybe that you want the court to order somebody to attend a trial evaluation, right? There's a custody case, and you want an evaluator, and you want the other side to pay for it or at least contribute to it. You file a motion in declaration laying out all your reasons and what you think the benefit is to the case and the child. And then the other side will file a response saying, no, I don't think this is necessary, and I don't think I should pay for it. And then the court may, if you ask for oral argument, the court may grant you, the court's required to grant you oral argument if you ask for it. But they may decide your case in your favor or against the other side. So motion practice is really important um, uh, to moving a case through the courts. And there are motions for everything. I was mentioning a petition before. In other areas of law, not so much in domestic relationships, uh, the petition, the wording of the petition has to be really particular. And if you screw up drafting it, the other side may say, hey, listen, I don't like the way this is drafted. I don't think it's right. And so there's motion practice on the language in the petition. Um, there are motions for something called summary judgment. Supposing you think that you are right on the law and the facts, you can file a motion for summary judgment where you say, "Hey, court, there's nothing here to fight about. We've got the facts on our side and we've got the law on our side, and you should just make a decision now so that we don't have to go to court." And that's called a motion for summary judgment. And in family law, those rarely happen. But other areas of law, they're more common. But it's just another example of a motion. Okay, we're gonna jump into trial documents. Um, so you filed the petition, you've had your court date set overs, you've um, gone through all the things that you need to go through, which we don't have to get into now, and it's the week before trial, and you're thinking about the trial, and two attorneys are sitting at their respective desks, and they're all, and they're preparing for trial. One of the most important documents for any trial is the hearing memorandum. The hearing memorandum lays out for the court uh, what the issues are in the case and what people's positions are. When I do a hearing memorandum, and when most attorneys do a hearing memorandum, it's a really carefully constructed um, memorandum, a really carefully constructed writing, and that kind of gives the court a roadmap for where the case is going before the evidence starts coming in, so that the judge isn't being surprised or just can start thinking about the case before he actually or she actually gets on the bench. So the hearing memorandum is very important. The other thing that the other type of document that one needs for a trial is an exhibits list, and those just tell the court that they do two things. They tell the court what exhibits are likely to be offered, uh, and it's also like a tracking mechanism. So, you can track offered and accepted or offered and declined. You might offer an exhibit and the other side objects and the court doesn't let it in. You track that too on the hearing exhibit. Another trial exhibit is a witness list. Um, Witness lists used sometimes, not often. They're not really required, but sometimes people will produce a witness list, particularly if they're out of if it's a big case or um, it's just not a lot to say about witness lists. Uh, I will say I did omit something when talking about motions. Every motion is accompanied by what's called discussion, and the discussion section outlines like what um, what the law is and how the law applies to the facts in a case. So it's usually a separate document that lays out what the issues are, what the facts are, what discussion is, and what the conclusion is. And the hearing discussion will just lay out for the judge, this is what I think um, should happen. This is what I think the law is, and this is how I think that law applies to this case. And so, in anything but the most routine, there's always going to be an accompanying memorandum uh, accompanying the motion. And for attorneys, it's like the best way to think through your arguments and familiarize, make sure that you know and are current on what the law is in a given area. Um, so let's move on to standards and certifications. And what am I talking about? So the first question is, who can sign a pleading? And uh, the actual party can sign a pleading unless they're represented by an attorney, and then only the attorney of record can sign a pleading. Sometimes attorneys get jammed up and somebody has to sign on their behalf, but generally it's the attorney of record who signs a pleading. When they sign a pleading, they're doing it pursuant to Oregon Rule of Civil Procedure, ORCP 17. And ORCP 17 says that anything you sign has to be well grounded in fact, and there are sanctions for not doing that. So if you're submitting false statements in a motion or on a certification, which I'll talk about in just a second, you could be subject to sanctions for that. So um, there is some um, what's the right word? Some regulation of um, what's in the pleadings, what the content is from the courts through ORCP 17. ORCP is in fact saying that you have to be honest about what you're signing, and that it is in fact well grounded in fact. Uh, there, it didn't make it onto this page, but certifications. There's certain things that you have to certify to the court. In a family law case, you have to certify that there's no other proceedings going on, or that there's nothing pending between the parties. In every case, um, Oregon law, Oregon pleading law changed a couple of years ago, and you have to now tell the court that the document, it's called a certificate of readiness. And you now have to tell the court that the document is ready to be signed or not signed by the court. It's ready to be signed because everybody agrees to it and has signed it and it's good to go, or that there's still disagreement about it. If there's disagreement about it, the court may hold a hearing. The other side may submit uh, um, a brief saying that they disagree with the way the judgment is or the motion is because of these reasons. Uh, um, or the court may set up a hearing on that to hear, why someone doesn't want to sign a judgment or an order. But everything has to be certified now that it's either ready to be signed or not ready to be signed. And that changed Oregon practice quite a bit over the last couple of years. The other certifications are you have to certify that you have served your document on the other side. And that's changed a little bit now that there's e-filing because the court will serve the other side. But every document is accompanied by uh, a certificate of service so that the other side, so the court has knowledge that the other side has in fact been served. So you can't sign, you can't um, like ask for a trial date to be set over and not tell the opposing party. You have to give the opposing party contemporaneous knowledge that you filed these motions, whatever it is. Okay, so that's like a lot about uh, uh, documents. Um, what are the what I do want to come back to what are the standards. So uh, there's a book of rules called the Uniform Trial Court Rules, and the Uniform Trial Court Rules set out what the standards are for pleadings, like what they're going to look like, what the typeface is, how big the type is, how long it can be. Uh, and it just goes to the nth degree about like numbering and how the captions are laid out. So, uh, and that makes a lot of sense because the courts want to read uniform. If you're a judge and you're reading pleadings all day, you want them to be uniform so you're not, oh, what's going on here? I got to figure something out new each time you start it. So it makes sense that the documents are going to be reasonably standard and uniform across counties and across attorneys. Uh, and those standards are very, very important to get right. And uh, every now and then a case will get kicked back because it doesn't meet the right standards. Where can you find documents? So when you hire a lawyer, the lawyer's job is to draft the documents. Like that's not necessarily the number one job, but the attorney's got to be able to draft documents that are coherent and read well and are intelligible and well informed and all of that. That's what lawyers do. Um, good. Every now and then I get something from an opposing counsel. I'll look at it and go, a lot of this stuff is really standard, but something every now and then will just stand out as being really exceptional. And that's just great to see when people are doing that kind of work. Uh, but it's got to be typo free. It's got to be accurate. It's got to be laid out correctly. So you got to follow the standards and you got to do the work to get it right. All right. If you're pro se, if you're representing yourself, if you don't want to hire a lawyer, you can't afford a lawyer, you can find documents online for yourself. And you can go to any of the county courthouses and look up divorce. There's always going to be a divorce section. And within that, there will be a section called divorce forms. And you can download any of the kind of documents that you think you'll need. Some of them are PDFs are fillable PDFs. Others are just downloaded and you have to fill them out by hand. Uh, Most of the courthouses have family law resource centers, and they will look over the documents before you file them. They will tell you, you will hear this, we're not attorneys, we can't give advice, but they can look over the documents and make sure that you're like at least using the right, generally the right form of document. And so you'll find all kinds of documents, everything from postponing a trial to contempt motions to uh, motions to get temporary relief from the court. So go to the county, your county courthouse. That will have the documents that county is used to using, right? And use their forms. The Oregon Judicial Department, the department that actually administers the courts, also has very good forms on it, and that's another good source for forms. The forms are free. You just need to bring them down to the courthouse to file it. I don't think that the public can upload documents to the court files, but you bring them into the court completed, and they'll go to the family resource. They'll help you out, and then you just bring them to the counter, pay the money, and file the forms. And almost lastly, let me just go through a couple of final points. Court pleadings move a case to the courts. The whole point of the pleading is to ask the court for something, uh, or to ask the court to do something to somebody else. And court pleadings is the way you do that. You initiate a case with a petition or a complaint, and that always ends in a judgment. You ask the court to do something through a motion. The motion is supported by a declaration, and then a brief that explains what you want and why you're entitled to it, and ends in an order, right? So those are like the basics of pleadings. You can request something of the court through a motion. We talked about that. The most important court document is always the judgment. It doesn't matter what kind of case it is, whether it's a criminal case or a car accident case or a tax case, it's always going to end in a judgment, right? If it's a divorce, it's going to be the general judgment of dissolution. If it's a custody case, meaning that there's a child but no marriage, it will end in the general judgment of custody. So judgment is always where you want to get to. And then finally, courts are, in fact, pretty particular about how documents are prepared. It's not unusual to get a document kicked back because you made some minor error or some major error. It happens. Uh, but that's uh, um, you got to know how to do it. If you use the prepared forms, you're not going to make that many mistakes. If you try and draft something on your own, it's going to be tough. The rules are pretty complicated. But if you're so inclined and you want to look it up, it's in the UTCR, the Uniform Trial Court Rules. So that's been about a half hour of everything you want to know about divorce forms. Again, I'm happy you joined me tonight. Uh, Again, if you have questions or you want to talk about anything in this presentation or any of my other presentations, please reach out to me. I'm always happy to get the calls. So thank you and good night, and thank you for attending tonight.